A systematic look at debt collection and defending yourself in a debt lawsuit. Brought to you by yourlegalleg.com, your advantage if you're being sued by debt collectors. Hey everybody, in this video I'm going to do something that I don't usually do. Most of the time my videos are pretty brief. I look for a handle, you might say, a specific issue or problem that you might encounter or hear about in a debt context, and try to use that to lead you to the bigger picture. I talk about hearsay because that rule of evidence is one of the most important rules that you're going to encounter in defending yourself. Or about verification, because demanding that is one of the first things that you can do to start protecting your interests. I tell you about how to make affidavits and why that matters, or how to stare down a motion for summary judgment, or lots of other things. And my goal in all of the hundreds of videos I've done is to make you see that you can defend yourself, and that you should, and that however much effort it requires, it's worth doing. Most of my videos have left you to draw your own conclusions about the bigger picture, although of course I've told you that we can help doing the things that need to be done. But all of these are just pieces of a larger puzzle, and I'm painfully reminded of that when someone tells me I did this or I did that and seems to think that it was enough. They think it was enough and think they should win or should have won if they lost. And they can tell me that they won or lost or they are still in the middle of things. That doesn't matter so much. Because what they're telling me is that they saw one or two of my videos, or perhaps a lot of them, and seized on one or two ideas as if they were the key to winning if you get sued by a debt collector or by an original creditor. That part doesn't matter. But the key to defending yourself from debt collectors or original creditors is never one or two things. It's always doing everything you can do. A debt collection lawsuit is a serious matter. These days, I mostly hear from people who are being sued for at least $5,000. Back when I was practicing, I handled suits from $250 to $50,000, but whatever the amount, it always had a major impact on my clients. Most of the people watching this video need to win. Losing would be a serious setback, right? In the final analysis, you always have to decide how hard to try at anything, how long, and how much work to put into it. But if you really need to win, stop asking, what does it take, and start saying, whatever it takes. Lawsuits are a contest. You don't go into a boxing match saying, I'm going to throw 3 punches, hope that works. If you want to win, you throw 1 punch and then you look for the next opening, right? And sorry for the violent imagery, but a lawsuit is a sort of fight. You keep fighting till the bell rings. You can get sucker punched at any time. And the ref can give you a bad ruling, right? That's always a possibility. So this video is about the bigger picture, the whole contest. It will be longer than most of my videos, as you've probably already figured out. We'll look at the debt industry and the players, talk about your chances and what you can do. And we'll talk about some of the things I do that might be helpful to you, including a new product or program I've come up with. For purposes of this video, when I say debt collector, I only mean someone who's after you for money you supposedly owe for some reason. I'm not drawing a distinction between debt buyers, debt collectors, original creditors, and all of that. I'm not going to use debt collector in its legal sense, only in a functional sense. We're talking about people who are bugging you for money or suing you, claiming that for some reason you owe them. We'll talk about the whole debt collection machine, from the bugging stage where they're just harassing you for money, to the lawsuit stage where the rules change and it gets worse. And we'll even talk a little bit about the collection phase, when they start garnishment or other actions to take away your money. They're all part of the same process. If you've heard many of my videos, you've probably heard me describe the debt industry. So forgive me for repeating myself, but I want to make this video pretty much a complete story. I'll try to keep things as brief as possible. There's over $1 trillion in credit card debt. That's what they all say, and that's a huge number, but I think it's even worse than that. I think that when they're talking about how much debt there is, they're referring to debts that people are trying to pay. We all know that after trying unsuccessfully to pay debts, most people stop trying to pay them. They stop getting counted as debts, but the debt collectors don't stop trying to collect them, right? And thanks to a recent Supreme Court decision, debt collectors could come after you for debts that are 20 or 30 or even 50 years old in some situations. The only other thing with no statute of limitations is murder. That's debt and murder. They never run out. Now, there is a statute of limitations that affects the ability of the company to sue you, but the debt continues, and that turns out to matter. But I'm not going to talk about that anymore here. Student loans always get that treatment, and now so do all other debts, so if you declare bankruptcy. So debts effectively last forever, whether they're counted or not. Plus, on top of credit card debt is car loans, payday loans, student loans, house foreclosures, utility bills, and the list really does go on and on. Debt collection is a huge industry in the U.S. and in other countries as well, although most of my comments and all of the statistics that I'm going to say relate to the U.S. So what happens with all this debt? You know the answer. The original creditor gets your payments for a while when you're paying. Then, if you get behind, they call you for a while. They may give it to a traditional collector to bug you at some point, or mostly they've discovered that it's more efficient to sell it to big corporations who bug you and then sue you. These are the debt buyers. Why is it more efficient to sell the debt to big collection company debt buyers? The reasons are pretty grim. The collection companies are immune from public opinion. They can freely hire sociopaths. They can lie, cheat, steal, and abuse, and do it all on a grand scale without worrying about their reputation. Original creditors, they can't do any of that. So they sell it to the people who can. So how do they sell the debt? I mean, mechanically, physically. They sell it by auction, for the most part. The selling party offers, let's say, $5 million worth of nominal debt. That means the amount of money that's supposedly owed without any discount to the market. They accept bids, and the highest bidder wins the debt. The debts are packaged with other debts that are similar in age and other risk factors. So an account that hasn't paid for 20 years won't be packaged with one that's 2 months late. This is so that the debt collectors can sharpen just the right tools to try to pry it out of you. And the debts are packaged geographically as well. The people who supposedly owe the debts live close to each other. The debts can go for 50 to 75 cents on the dollar, all the way down to small fractions of cents on the dollar of nominal debt. The debt collector might buy $1,000 of nominal debt for $500, or might buy it for $50, and maybe less than that, depending on these risk factors. Once they sue you, though, the price paid for the debt has no legal significance whatsoever, and not much practical significance either. They'll go after you for the whole amount, plus interest. Don't be fooled on that. Is it legal to buy and sell debts this way? Yes, it is. Unless there's something specific in the contract that creates the debt, it is perfectly legal to sell it to someone else, and there's almost never anything in the contracts that stop that. In fact, our commercial and legal system favor the easy transfer of debts to other parties. And as a matter of fact, as some people love to point out, our very monetary system consists of the easy transfer of debts. Take a look at a dollar bill. If you do, you'll notice that it isn't actually a dollar bill. It's a Federal Reserve note. And what is that? It's a debt. When someone hands you $1, they're handing you the theoretical right to collect someone else's debt. That someone being the Federal Reserve. It's complicated by various laws, but at one legal level, a cash purchase is a transaction involving the free assignment of debt. Now, I know that talking about the money system is going to tempt some people to go in an unhealthy direction. We're not going there. My job is to get you out of trouble, not show you how to get into more trouble. The point I'm making here is that assigning debts is easy, normal, and accepted. And the debt collectors plan to collect from you. That's all you need to know about this part of the deal. The question we face, however, is how to keep them from doing that. That's the only question I'm interested in, and if you're being sued, it's the one you need to answer in a way that gives you your best chance to keep your stuff, right? They'll bug you for it as long as it seems a good idea for them to do, if at all, and then they'll sue you. The bugging part and the suing part are different. During the bugging part, an original creditor has few legal limits on what they can do. But they don't want to spend their time bugging you, and they have reputations to consider too. On the other hand, companies that are not the original creditors don't have those market concerns, and thus the Fair Debt Collection Practices Act, the FDCPA, was passed to give you some legal protections at that stage. And most states also have some version of the FDCPA as well, which is they are different laws, and that's important to keep in mind when you are in litigation. During the bugging stage, these rules, the FDCPA and so forth, require the debt collectors, and now I am talking about companies defined as debt collectors, to do certain things and not to do other things. I've talked a lot about this in other videos. Generally, debt collectors are required to be honest and fair in the collection process. They can't threaten you with things they can't do or don't intend to do, and they have to notify you of certain rights, all of that theoretically, right? And we'll leave it at that for now. I have a lot of materials elsewhere on this point and other things to do right now. Remember, though, that everything changes when they file suit. At that point, the FDCPA mostly no longer applies, with minor exceptions that aren't really going to matter to most of you. When they file suit, the debt collection rules go out the window and the rules of court start to apply instead. This is a critical distinction. At its simplest level, it means that if they file suit, you can't ask for verification or proof of the debt. Doing so has no legal effect at all. On the other hand, you can conduct discovery pursuant to your state's rules of procedure, which happen to be a lot more powerful, and you should. So let's talk briefly about the suing part of the debt collection process now. I want you to see why you have a good chance to win, and I want you to see that in order to have that chance to win, you have to defend yourself intelligently. We'll come back to that phrase, defend yourself intelligently, in a while. It's going to be important. As I said earlier, the debt collectors buy huge amounts of debt in bulk. It isn't uncommon for them to buy several $1 million worth of nominal debt at a time. It goes into their mills, and they bug you for a while, and then they file suit. Do you think they file suit one suit at a time? Of course they do not. They file them 50 or 100 at a time. Why do they do it this way? Basic question. And the answer is just as basic. It's efficiency. And this is another critically important part of the collection process that you need to know. They do it that way so that they can create one petition and copy it 100 times. They often use fill-in-the-blank formats. You may think that's lame, but it means that one lawyer can do 100 petitions in an hour, or actually much less, because they've already done it enough to have the form on file. Got it? It costs no legal time at all to file suit against you. Then their lawyer goes to court for one day and handles 100 lawsuits in an hour. If 80 of those suits result in judgment in that 1 hour, at $5,000 apiece, they have judgments totaling, say, $400,000. Not bad for 1 hour's work, right? Of course, there's more to be done after that. The whole collection process is a messy thing, but that's the way the debt lawsuit business works. See how amazingly efficient it is? We're going to contrast that to what you have to do if you want to defend it in a minute. And the debt collectors realize that most people will not show up anyway, but that More of them can be scared away from defending if they do certain tricks. So of course they do. And we talk about some of those tricks in other videos and materials, so for now I won't discuss them. Just be aware that while debt collection lawyers who work the cases are not necessarily high-level legal minds, the people behind them, they definitely can be, and often are. So you've got a system that's designed to function like a factory, as I've often pointed out. And all I'm going to say about defending right now is that it's very much in your interest to take the case out of factory mode. How do you do that? Well, you defend intelligently. When you file an answer to the lawsuit, you've already put yourself in a relatively small minority of cases. They had 100 cases, and 80 to 9 of them went away on the first day, and 10 to 20 of them maybe are left. Anything they do with you from that point on will obviously be much less efficient than what they did first, right? But they are prepared for your answer, and they can still go to court 10 times cheaper than you can. Why do I say that? It's just mathematical. We'll talk about lawyers in a bit, but for now, let's say you do manage to hire one, and it costs $100 an hour to make the math work easily. If your lawyer goes to court for you and spends an hour hanging around waiting to do something for you, it will cost you $100, right? Simple as that. At the same time, there will be 9 other lawyers doing that for their clients, while the debt collection lawyer does the same thing for 10 clients at that time. The math is simple but powerful. The defendant spends $1,000 while the plaintiff spends $100. And while I fiddle with the numbers, it really does work that way. Just that way. Now suppose that there's some actual legal work to be done. Your lawyer will spend another hour doing research and writing, and so will all the other defendants' lawyers. But the plaintiff's lawyer will have already done all that research and writing for the last bunch of cases. So the defendants buy another $1,000 worth of attorney time, but the plaintiff's lawyer may spend 20 minutes, 33 minutes worth of time for all of them. And it really works that way too. You might think I'm exaggerating, but the last case I was involved in, helping a lawyer friend a few years ago, involved a judgment for, as I recall, $5,000, could have been $10,000, I don't know. It's a bunch. The plaintiff's lawyer said he had spent 18 minutes to get it, including drafting and filing the suit, attending court and getting the judgment, and drafting and giving the court post-trial stuff. That's 18 minutes for all that. So that's the initial math. Pretty rough, right? All right, now let's take a quick step back and consider something lawyers love to do, settle cases. Suppose your lawyer talks to the debt collector lawyer about settling your case at this point. You'll have spent a couple $100 using the crude math that I've been using, much more in real life, of course, versus the collection lawyer's $3 in fees, because he got to divide his $33 into tenths. The collection lawyer knows it will cost you 10 times or more as much to defend as it will cost him to attack. What would you do if you were him? You'd set a higher price, wouldn't you? And unless they know your lawyer and know he's as efficient as they are, that's just what they're going to do. Talking to a debt collection lawyer at this stage about settlement is usually pretty useless, but most lawyers will say you should settle as quickly as possible if you try to hire one. And that's true of other kinds of law, but not this kind of law. You can see that, right? But as you defend, as you serve discovery and pursue it, you increasingly force the debt collector to spend time closer to a 1-to-1 ratio. On a motion to compel, for example, their lawyer has to look at what you said regarding very specific questions, address your very specific arguments, and go to court and argue very specifically with you. Do you see how that changes the economics for them? The same lawyer who got $400,000 worth of judgments in an hour must now spend an hour arguing with you without getting any judgments at all. And this is also the way it works in real life. Please look at the bottom of your screen down in the About This Video section. You will see a link to the next part of this video. That link will take you to our site where this video and the next part are housed. You'll also be able to download the full transcript of the whole video in PDF format if you like. As you might guess, there's a time-sensitive offer that I'd like you to see that comes at the end of the videos. See you there.